Legal and ethical issues in education. The first thing I want to talk to you about today is religion in public schools. The First Amendment of the U.S. Constitution addresses personal freedoms of students and school personnel involving speech, press, assembly, and religion. The Establishment Clause added to the First Amendment prohibits the state from passing laws that aid a religion or show preference for one religion over another. Another clause added to the First Amendment is the Free Exercise Clause. It prohibits the state from interfering with individual religious freedoms. The next thing is school-sponsored prayer. There are several lawsuits that have paved the way for what we do in schools now regarding prayer. Jones versus Clear Creek Independent School District. Non-school sponsored, student-initiated prayer at graduation ceremonies is permissible. This lawsuit stated that it does not violate the First Amendment regarding the separation of church and state. However, in Engel versus Vitale, when a non-denominational prayer was recited by a class at the beginning of the school day and students weren't allowed to be excused, the state and the high court ruled this was a violation of the First Amendment. So what does this mean for educators? This means that school-sponsored prayer is illegal based on the Establishment Clause of the First Amendment. However, voluntary student-led prayer is permissible under the Exercise Clause of the First Amendment. In school-sponsored Bible reading, there are a few court cases that have led the way. Murray versus Curlett. In 1963, the United States Supreme Court ruled that daily Bible reading was a breach of neutrality. The courts ruled that school prayer and Bible reading violates the Establishment Clause of the First Amendment. In the Abington School District versus Shemp, in 1963, the Supreme Court ruled that school-sponsored Bible readings in public schools is unconstitutional. Courts did specify that the use of the Bible for historical, literary, ethical, or philosophical purposes is permissible. So what does this mean for educators? It means that school-sponsored Bible reading is illegal, but the Bible can be used for instructional and educational purposes. The next thing we want to talk to you about is the freedom of expression for students. Students are entitled to First Amendment rights as long as actions do not create material or substantial disruption in the educational process. There are two vital lawsuits that have paved the way for the freedom of expression for students. One in 1969, the United States Supreme Court ruled that students possess the same constitutional rights as adults. This is when students wore armbands in protest of the government's policy for Vietnam. In 1966, students were denied being able to wear freedom buttons to school. The courts supported the principle in suspending those who did not stop wearing the buttons. The difference in these two court cases was that there was no evidence of disruption in the school in the Tinker case. But in the Blackwell case, there was significant evidence of disruption. Basically, decisions in these cases must be made on a case-by-case basis. This brings me to the topic of protests and demonstrations. Protests and demonstrations are part of free speech, and students are entitled free speech under the First Amendment. School officials may prohibit free speech in the way of protests and demonstrations if there is evidence of material and substantial disruption of the school day, indecent or offensive speech, violation of the school rules, destruction of school property, and the disregard for authority. The next topic I want to talk to you about is school-sponsored versus non-school sponsored newspapers. In 1988, the U.S. Supreme Court ruled in favor of the principal of the Hazelwood School District by ordering the removal of some material because of it being controversial. The next case I want to talk to you about involved a non-sponsored newspaper. A court of appeals supported a school in prohibiting the publication of material that was indecent and vulgar. In order to have a newspaper, legally defensible editorial policies must be in place. Restrictions should not be enforced unless there is evidence of disruption or defamation, remembering the student's First Amendment rights. Impermissible material would include anything that is vulgar, obscene, libelous, and mocking of others based on race, sex, origin, color, or religion. Illegal search and seizure. The Fourth Amendment of the United States Constitution provides protection for all citizens against unreasonable search and seizure. Reasonable searches include reasonable suspicion, reliable information from a reliable source. It cannot be on a gut feeling. AH versus state court case did not meet reasonable suspicion since the teacher only had a gut feeling. Educators need to know that reasonable search and seizure must be demonstrated in order to search students. Searches include, but are not limited to, text messages and social media platforms, student lockers, student vehicles, student desks, student book bags, their purse, computer bag, etc. Students with disabilities. Individuals with Disabilities Act of 1975. The Individuals with Disabilities Act embraces the notion that children with disabilities be placed, when appropriate, in educational settings that offer the least amount of restrictions, their least restrictive environment. Irving Independent School District versus Tatro determined that students be placed in educational setting to the maximum extent possible with non-disabled peers. What is an individualized education plan? An IEP is a plan that is developed to ensure that a child who has been identified as having a disability who is attending receives specialized instruction and related services. So what is a related service? A related service is a service such as speech therapy, occupational therapy, physical therapy, or other services that is related to the educational experience of the student. What does this mean for educators? Educators must follow the IEP. You must implement accommodations according to the IEP. And you must know that you are an active member of the IEP team. Liability and student records. What is FERPA? The Family Educational Rights and Privacy Act is a federal law that allows parents the right to have access to their child's educational records, the right to seek to have records amended, and the right to have some control over personally identifiable information from the records. When a child turns 18 or enters a post-secondary institution, the rights under FERPA transfer from the parent to the student. A release of information must be signed by parents before personally identifiable information can be released regarding a student under the age of 18. So what does this mean for educators? Number 1, be careful what you share with other educators or staff. Number 2, it's a good rule of thumb to not type names in text messages or emails. It's also a good rule of thumb to use their first initial and last name or just the initials of the student. Number 3, only share what is necessary with whom it is necessary. Alabama Educator Code of Ethics. What is the Alabama Educator Code of Ethics? The Alabama Educator Code of Ethics is designed to protect the health, safety, and welfare of students and educators. The Code of Ethics defines actions that are considered unethical in nature or for which disciplinary actions are justified. Are educators required to report a breach of the Code of Ethics? Yes, educators are required to report the breach as soon as possible and no later than 60 days from the date that the educator became aware of the alleged breach. What are some possible disciplinary actions? Disciplinary actions could be a warning or reprimand, a suspension or revocation of the teacher or leadership certificate. The standards for the Code of Ethics: number 1, professional conduct; number 2, trustworthiness; number 3, unlawful acts; number 4, teacher and student relationships; number 5, alcohol, drug, and tobacco use or possession; number 6, public funds and property; number 7, remunerative conduct; number 8, maintenance of confidentiality; number 9, abandonment of contract. For more information about the Alabama Educator Act Code of Ethics, you may click the link in this PowerPoint. What is due process? Due process is a course of legal proceedings established to ensure that the state respects all legal rights and protection of private rights. Due process balances the power and protects the individual. What should I know about due process in Alabama? The Due Process Clause of the 14th Amendment, like its counterpart in the 5th Amendment, provides that no state may deprive any person of life, liberty, or property without due process of law. This clause applies to public school districts and provides the minimum requirements of the procedure that each school district must satisfy when dismissing a teacher who has attained tenure. The United States Supreme Court of Cleveland Board of Education versus Loudermill provides that a tenured teacher must be given oral or written notice of the dismissal and the charges against him or her. Also, an explanation of the evidence obtained by the employer and an opportunity for a fair and meaningful hearing. These are our references.